Got a question asking what are the rules if a person purchases a property at like a foreclosure sale? We'll call it a trustee sale. We're talking non-judicial foreclosures. Hi, my name is Rob Wells. I'm the landlord warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I'm just going to preface this question on this questionnaire is probably talking about a non-judicial foreclosure, aka for trustee sale held at the courthouse steps. There's no court process. There's two forms of foreclosure in California. The most common one would be like the non-judicial foreclosure. Hey, they post notice of default and notice of trustee sale and record that. And then you have a sale at like the courthouse steps or city hall or whatnot. That's one type of sale. The other type of sale is like a judicial foreclosure. You file like a foreclosure lawsuit in the Superior Court and you get a judgment. So we're not talking about the judicial foreclosures, we're talking about a foreclosure sale. So in those situations, purchasers got to be careful because the problem is this. If you're talking about evicting tenants from a foreclosure sale, basically tenants' rights under like any local just cause ordinance or even the state's Tenant Protection Act don't go away. Okay, so you may be subject to just cause eviction, whether at the state level or at the local level. Okay, that being said, there are a couple of code of civil procedure sections that authorize eviction, and they're somewhat different than the regular landlord-tenant evictions under Code of Civil Procedure 1161. Okay, we're mainly talking about code sections 1161A and 1161B. And 1161B governs the protections for tenants. Okay, so two scenarios, right? Let's say there's a foreclosure sale and you got the home, right? You got a deed basically, and there's actual tenants. There's no owner or first degree relative of the owner, such as a child, spouse, parent, or of the owner that got foreclosed on lived there. Okay, so under 1161B, generally speaking, if it's a month-to-month tenancy, that landlord would have to give at least a 90-day notice to terminate the tenancy, and that's outside any just cause provisions. Okay, so if you're subject to Tenant Protection Act or a local ordinance, under state Tenant Protection Act, a foreclosure sale is not cause. Okay, and I probably suspect under a lot of local ordinances it's not cause as well too. So you may not be able to terminate the tenancy, but if you were exempt from any type of eviction control at the state or local level, 1161B states you got to give at least 90 days notice, okay, to vacate. Okay, if it's a fixed lease, 1161B subdivision B states that the tenant gets to stay there through the end of the lease term, or up to, except that the 90-day notice could be given on certain circumstances, such as if the purchaser, aka successor in interest, will occupy the property as a primary residence, or the tenant that leased the property that there's a fixed lease on, they are the actual borrower, aka mortgagor, or the child, spouse, or parent of the borrower. Okay, mortgagor is what's in the code. The lease is not a result of an arm's length transaction. That's like, basically meaning if the rent's like $400 and the going rent's like $3,400, that would probably not be something of an arm's length transaction. And then this kind of goes into the fourth ground. The lease requires a receipt of rent that is substantially less than fair market rent for the property, except when rent is reduced or subsidized due to federal, state, or local subsidy or law. Okay, so usually back in the day, like the foreclosure crisis 2008 type deal, we would have owners getting foreclosed on. They would enter into a lease to avail themselves of protection under state and federal law. Okay, and 1161B was amended to comply with federal law because the 90-day requirement is really is by federal law. I believe the old 1161B like actually sunsetted, and then they had to like reenact it because of federal law. But that's what's on the books. The problem is this: for anyone buying these properties, you're going to still be subject to localized eviction and rent control, and hypothetically the state's Tenants Protection Act, because the state's Tenants Protection Act of 2019 covers any lawful tenancy, basically, what have you. So care is going to have to be taken to review the facts if there is a bona fide tenancy and so forth before you issue notices, because you could be starting over again, or you could worse find out in court that the eviction is improper. So folks, if you're in the Northern California area and you need help terminating a tenancy, you don't know what the rights are of the occupants and so forth, feel free to reach out. We might be able to help out. Put your comments, questions down below. I'll answer them to the best of my ability. Until next time, folks, talk to you then. Thanks.